You are standing by a swimming pool. Someone falls in. They are drowning right in front of you. You are a strong swimmer, and there is a life ring within reach, and you do nothing. You walk away. Are you guilty of a crime? In English criminal law, the answer might surprise you, and to understand it properly, you need to understand actus reus. Welcome to Storm Notes. Our last video was all about the mind. Today is all about the act. Our topic, actus reus. It's Latin for guilty act. It is the external, physical element of a criminal offense. Together with mens rea, the guilty mind we covered in the last video, it forms the foundation of almost all criminal liability. Actus reus can take three forms. It can be a conduct, the act itself, like dangerous driving. It can be a result, where the offense requires a specific outcome, like death in murder. Or it can involve circumstances, the surrounding conditions that make an act criminal, like the absence of consent in a sexual offense. Here is something that gets overlooked more than it should. The act must be voluntary. The defendant must have been in conscious control of what they were doing at the time. If someone commits what would otherwise be a criminal act, but their body was acting entirely without their conscious control, that is automatism. And automatism means no voluntary act. No voluntary act means no actus reus. No actus reus means the foundation of the offense is missing entirely. Think of a driver who suffers a sudden and completely unforeseeable seizure and injures a pedestrian. Their body acted, they did not. That distinction matters enormously in law. Now, back to the swimming pool. And this is where English criminal law does something that surprises a lot of people. The general rule is that there is no criminal liability for a failure to act, an omission. You have no general legal duty to save a drowning stranger, as uncomfortable as that might feel morally. But there are well-established exceptions. Situations where the law does impose a duty to act, and where failing to act can make you criminally liable. The first is a statutory duty. Parliament can create offences based on failure to act, failing to provide a breath specimen, for example. The second is a contractual duty. In R versus Pitwood, a railway gatekeeper failed to close a level crossing gate. Someone was killed. His contract required him to close it. He failed that duty. He was liable. Third, a special relationship. In R versus Gibbons and Proctor, a father failed to feed his child. The child died of starvation. The parental relationship in this case created a legal duty to act. Failing to act was enough. Fourth, voluntary assumption of responsibility. If you choose to take someone into your care, you take on a duty for their welfare. In R versus Stone and Dobinson, a couple took in a vulnerable relative who was unable to care for herself. They failed to get medical help as her condition deteriorated. She died. The voluntary assumption of care created the duty. And fifth, creating a dangerous situation. In R.V. Miller, a man accidentally started a fire and then simply walked to another room and went back to sleep. He did nothing. They failed to get medical help as her condition deteriorated. He court held that once you create a dangerous situation, even accidentally, you have a duty to take reasonable steps to address it. So, back to the pool. Random bystander? No legal duty, no liability. But if you are the lifeguard on duty, you have a contractual duty. If the person drowning is your child, you have a duty from your special relationship. If you pushed them in, you created the dangerous situation. In each of those cases, doing nothing is doing enough to attract criminal liability. One more principle worth knowing, and it connects to the last video. The actus reus and mens rea must coincide. They must exist at the same time. If the guilty act happens without the guilty mind, or the guilty mind exists but the act does not follow, there is no complete offense. Courts have occasionally been flexible about what counts as a continuing act, but the core principle holds. In any criminal law problem question, your first job is to identify the actus reus. What was the act? Was it voluntary? If there was no act, was there an omission? And if so, did a duty to act exist? Only once you have established actus reus, do you turn to mens rea. Both elements present at the same time. That is when criminal liability attaches. If you want actus reus laid out clearly on one revision-ready page, every type, voluntariness, the 5 duties to act, the key cases, and exam application tips, The Storm Notes Lightning Pages has it all. The link is in the description. One page, everything you need. So, to wrap up, actus reus is the guilty act. It comes in 3 forms: conduct, result, or circumstance. It must be voluntary, and sometimes, crucially, an omission where a duty to act exists. If this helped, hit like, subscribe, and drop a comment below. Did the omissions rules catch you off guard? Free resources are in the description. Storm Notes. Zero fluff, pure knowledge.